With that, why don't we get started with People versus Dixon Bay.
May it please the Court, Jerry Scrotenborn, Jackson County Assistant Prosecutor for Plaintiff Appellant. I have two main points on this. First, the judge did not abuse his discretion in giving the sentence he did. He looked at the evidence, made his conclusions, and accordingly fashioned the sentence. Brutally murdered in cold blood. The judge who sat through the trial based this conclusion on the, quote, evidence of his sentences and the reality of his conclusions, to slightly paraphrase this court's opinion in Ewing. Now, a judge has a right to conclude, the second point, judge has the right to conclude that the defendant, by a preponderance of the evidence, is really guilty of first-degree murder. An acquittal does not mean the person did not do it. It means the jury did not find guilt beyond a reasonable doubt. Both Ewing and the U.S. Supreme Court in Watts in '97 said that a judge may consider the underlying facts by preponderance as long as you do not go above the maximum for the crime that the jury convicted him of, which of course did not happen here. And OV6 does not forbid a judge from doing this. OV6 is merely scoring the guidelines. It's not proportionality analysis. And what this court said in Steenhouse is that all the guidelines are discretionary. It didn't say, oh yeah, there's one exception to that. It did not. And the Court of Appeals here did not follow what this court said in Steenhouse. Now, the U.S. Supreme Court in cases like Gall has said that you cannot tie proportionality analysis too closely to the guidelines because you'll otherwise come close to making them mandatory again. And that's what happened here. The Court of Appeals paid lip service to what this court said. Page 525. Judge did not explain why a different sentence would be more proportional. In other words, closer to the guidelines. 525, 526. The judge's factors have already been considered by the guidelines. 528, OV6 constrains from finding premeditation. 529, well, these facts aren't really all that unique anyway. This analysis makes the guidelines very close to mandatory again. Instead, I'm asking the court to follow the federal cases that have been following what the U.S. Supreme Court said since Gall and Kimbrough. I've cited them in my brief. Rayon, Chavez Mesa, which is from the U.S. Supreme Court itself, and Sexton. In the end, I'm asking that the standard...
Counsel, good morning. Why do we have juries? If your argument is to be followed to its full course, why do we have a jury?
We have a jury to decide if the case has been proven beyond a reasonable doubt. And what we have in that situation is, remember, it's beyond a reasonable doubt. It's not by a preponderance. If it were by a preponderance, I would completely agree. But because it's by a reasonable doubt, let's take a little different situation, a situation of 404B evidence. In 1976, this court in Oliphant said, it doesn't matter that the defendant was acquitted. You can still, of the prior act, you can still use it for 404B. Now, if you say that then defendant's position in this situation would be the jury may consider that 404B evidence for proving guilt beyond a reasonable doubt, but the judge may not consider the same evidence in front of him by a preponderance of the evidence, and that makes no sense.
What is your argument due to the jury's verdict? The jury specifically acquitted this person on that charge. So what is your argument due to the weight of the jury's verdict? The jury took this, they considered it. It
does not change it.
They were very clear about making an acquittal. They were given these options, and this is what the jury decided.
It does not change it, because you can never go above the maximum for what the jury found. If the jury had convicted of assault and battery, the max would have been 93 days, period. And that's what the U.S. Supreme Court, they analyzed it in Watts. Every circuit had said that a judge may consider this by preponderance. However, the Ninth Circuit said, oh no, you can't consider it, and the U.S. Supreme Court reversed it. Said, yes, you can consider it. And the federal courts since then have said, oh, Sixth Amendment doesn't change anything on this. And let's also take a look at the O.J. case. Jury acquitted. Okay, fine. So what do we have? Does that mean that he's not guilty? We had a civil lawsuit after that.
Isn't there a distinction between a civil and a criminal situation?
Yes, there is, and it's precisely the same situation as here. It's called preponderance of the evidence versus, oh, come on. At times my mind just goes out.
Proof beyond a reasonable doubt. Can I ask the same question a little differently? It's interesting, right? Because it feels, I think, to a lot of people in our gut, like it can't be right when the jury has rendered a verdict.
I agree.
It just feels wrong. So,
yes.
But obviously we have to look to what the U.S. Supreme Court has said about it, and in fact, every court that's considered it as a Sixth Amendment question that I can find has said it's not a Sixth Amendment problem.
Yes.
But there are some courts that have found it to be a due process problem, a problem that implicates the defendant's right to have the charges proved beyond a reasonable doubt. Do you want to address that separate constitutional argument?
And you would say the same thing then about 404B evidence. The 404B evidence may be used. Let's say he gets acquitted in something. Later on, he gets charged with something similar, and you use the facts of the acquittal as 404B evidence. U.S. Supreme Court about 1989 said that was fine. 1976, this court said that was fine in Oliphant. You would come up with the same thing in that situation. But wait a minute, the jury. It's because the jury did not find guilt beyond a reasonable doubt. And if you want to talk about due process, that's what the U.S. Supreme Court was talking about in Watts. Maybe it didn't specifically address Sixth Amendment, though certainly plenty of federal courts have done that.
I'm not talking about the Sixth Amendment now either. What's interesting to me is the sort of mess that the doctrine around this issue is right now. So, McMillan was the original case where the U.S. Supreme Court said it is proof beyond a reasonable doubt is not the standard for a sentencing judge. It's preponderance.
Yeah, they said it before then, yes.
We weren't talking about acquitted conduct. So there's already,
that's true.
McMillan was not based on acquitted conduct. And is there something different about acquitted conduct and some of these other acts kind of evidence that a jury didn't consider and reject?
No.
Is there a different quality to those two batches of evidence for the purpose of punishing a defendant? Not for the purpose of, another trial and other bad acts, but for the purpose of punishing a defendant. Should we think differently about uncharged, unproven acts and acts that a jury has said we find the defendant not guilty?
No. Very simply, for exactly the same reason. If you say that you cannot use it in this situation, logically you would say you cannot use it for 404B, and logically you would even say, oh, that eliminates the civil lawsuit as well, because the jury acquitted. Oh, there was consternation that O.J. was sued directly afterwards. People were asking that question.
But they're apples and oranges and cantaloupes, right? Because
not really.
Whether you permit someone to be punished based on acquitted conduct is different from whether you permit that conduct in a future trial as consideration for a different, and whether you permit them to be held liable civilly. These are three different bowls of fruit.
Actually, in a sense, you're right. The point is only exactly the opposite way. A judge is allowed to consider practically anything. A judge is allowed to consider far, far, far more than the jury is allowed to consider. The jury is not allowed to consider the defendant's criminal record. A judge is. A jury is not allowed to consider that there's a pending charge against him. A judge is. All sorts of things.
My question is not whether the judge can consider it. We trust judges to be able to make these, to think through these questions better than juries. That's why we have those lines.
Yes.
The question is, can the defendant be punished for these different, are these different, piles of evidence are the qualities of them different for punishment purposes?
No. And the point is what this court said in Ewing, any other rule would require the judge to deny the evidence of his senses and the reality of his conclusions. You'd basically be telling the judge, okay, you've got to go to a hypnotist and get that out of your mind. You sat there and watched it.
Or you might be telling the judge that you have to respect the jury's verdict on the charge that was just tried in your courtroom. Mr. Schoenborn, I have a slightly different question for you.
Okay.
Under the regime you're advocating, are you going to go back now to your office and tell the trial prosecutors, or the warrant office prosecutor to be specific, that now the strategy should be to bring charges or to bring charges that the prosecutors know they can't prove beyond a reasonable doubt, that they only may be able to prove by a preponderance, companion charges, just for the purpose of the judge now sentencing the defendant as though he or she had been convicted beyond a reasonable doubt of those charges? Is that the strategy? Will that be the strategy going forward if your rule is to prevail?
Certainly not with myself. I would never do anything like that.
What would prevent that? And why? I mean, I'm not even sure that it would be unethical if your rule prevailed, if that's a legitimate way to proceed.
No.
Why not?
There are separate ethics for prosecutors that say you're not allowed to charge unless you believe you have sufficient evidence. And that would be an improper ground on which to do it.
Why? If your rule prevails, it's a legitimate consideration for a judge if the judge believes that the crime has been proved by a preponderance. Why would it be illegitimate? I don't understand what
because
would stop,
that has nothing to do with the actual prosecutor ethical requirement. And it, for one thing, it hurts your reputation pulling something like that. That would be completely improper. The ethics rules forbid it. I'm not saying that.
What if you just charge obstruction of justice and you have a catch-all charge? So, you bring up a person on a litany of charges, but then you add a few catch-alls that, in many situations aren't as difficult to prove, like I say, an obstruction of justice. So you throw in that charge. I mean, basically now should people be worried that if you get caught on a catch-all charge, but you get dismissed on the big charges, you could still face that type of penalties?
Well, we'll have to come up with a better example than that, because obstruction of justice is categorically forbidden if another statute happens to apply to it. It's not that easy getting an obstruction of justice charge.
But I'm not using that as a specific. I'm just trying to explain, cap on that component if you bring in, there's certain charges that are more catch-all, that kind of catch everything else. And so the question is that if a person gets found on a lesser charge, ultimately the jury's making a determination that this is what they want to find on a lesser charge. But your position should be, no, you could be found guilty in terms of the sentencing on the higher charge.
Well, in the first place, we haven't exactly had that particular problem, even though this has been the rule since at least the 70s. Michigan, there are plenty of cases that mention this in the federal court that you can do this. In the second place, Ewing, 1990. Third, Watts, 1997. And we're not exactly noticing that right now. So if this court basically says, oh yes, we're following the vast majority of jurisdictions, we're following exactly what we're doing, I don't anticipate that particular problem. And frankly, I'm having trouble. I've been a prosecutor, except for 4 years, since 1986, and maybe my mind just isn't working, but I'm unaware of any kind of catch-all charge
what
like
effect could this have on plea bargains? If I plead to one thing, can I now be sentenced to a different thing? It's the discretion of the judge. So what effect could this have on how the whole system operates?
That's always been the case. We go back, and I quoted in both of my briefs the cases from the Court of Appeals that says that a judge may consider the full facts of the case when a person pleads, but he cannot go above the maximum for what the guy pled to.
Do you think this could have an effect on plea bargains?
The problem with that question is it assumes that I'm asking you to change the law. I am not. I'm asking you to keep the law the way it has been the last few decades. And it has not, from what I can tell, had an effect on the plea bargains because it goes down a certain level. They work out the guidelines ahead of time. Yeah, discretionary guidelines, but they work out the guidelines ahead of time. And then, of course, we take a look at what the facts are. Oh yeah, Brzezinski from about 1992 said, of course the judge may consider what the person did as opposed to, he's not restricted to the facts that the defendant plea bargained his way down to. And that's the way that since at least the 40s...
Do you feel this lessens the role of the jury?
No.
I was asking you from your personal perspective, do you feel that this affects what juries do or their role in this process?
No.
Are there any further questions? He's out of time. Are there any further questions? Justice Bernstein, do you want to keep...
Well, I'm done. I just wanted to get your sense of this. You don't feel that that lessens the role of the jury?
I have not noticed that in the 29 years since Ewing came out.
Thank you, counsel.
Okay.
Well, good morning.
Morning.
Gary Strauss on behalf of Ms. Dixon Bay. And this Court's aware, I'll put the order 5 minutes of my time. Sorry, Ms. McCann?
We are aware, and I'll try and help you, but please do your best and try and keep track of it and sit down when you want Ms. McCann
Let me know when there's 10 minutes. I'm not that familiar. In answer to the first question, I believe the prosecutor kind of steered clear in his brief, and there are amici as well, that this Court's repeatedly stated that proportionality is adhered in the guidelines, also that it's a barometer to be used, and to stop disparity in sentencing. They're an important consideration. That's what this Court stated in Steenhouse and Lockridge. And in my view, the Court of Appeals followed what this Court has said repeatedly, also about the guidelines, that if certain things are reflected in the guidelines, they shouldn't be considered unless it's egregious. And the Court of Appeals, in this case, that's what they did. They went through everything and came to the conclusion that the judge abused his discretion. With the second question, if you respect the law, as this Court did, and the decisions of this Court, the judge did overstep his bounds there. The OV6, I think it is pivotal here, that with OV6, they do score culpability. Specifically, that's considered in the guidelines. That's a special guideline for murder. So the judge should abuse discretion by doing that. With the final part of your question, too, sure, the judge can use facts not found by the jury, but in some cases it's a case-by-case determination, certainly not in this case, because of the reasons set forth in the Court of Appeals. And then lastly, and quickly, I think the federal guidelines, all these references to the federal guidelines are completely different. This Court has stated as such, the federal guidelines are completely different. I've done a few cases, far from an expert, but their sentence reports are very detailed. They have relevant conduct as listed right in their reports. They're talking about relevant conduct, which could be anything. And I had a case where they made a plea deal, and told somebody that, well, we'll get rid of the attempted murder charge. Then in the space for relevant conduct, he's right back there and has the same points as if he was involved in it. So we believe that really this Court should just, I guess, reaffirm now for the third or fourth time after Smith and Lockridge and Steenhouse that we have to respect the guidelines. They're a very important consideration, and respect them as they apply to the case. The judge didn't do that at all. I mean, the guidelines are really the playing field upon which discretion operates. It's clear. And to just shoo them away and the judge could say, cold-blooded murder, that's enough. It's like the Wild West, and I don't think that's what this Court ever intended.
Counsel, you just mentioned Smith, and I agree with you that when you read Lockridge and Steenhouse, Smith is still embraced, and we make reference to the need to refer to the guidelines. But what we also know is that Steenhouse and Lockridge made these guidelines advisory, not mandatory. Mm-hmm. So Smith even though we say it should still be followed, that we have to articulate an extent to the departure, a reason for departure, it must mean something less than it did pre-Lockridge. How are we to now articulate what Smith should mean? We're going to look at the extent, but to what extent? Doesn't it have to mean something less than it meant before these cases came out?
Well, because it's a case-by-case determination, it's always difficult to pinpoint, the extent, 20%, 30%, but I think that the Court of Appeals in this case expressed it perfectly when they stated that they compared whether it was more proportional, and of course, opposing counsel are going to latch onto that. It's not more, but I think you got to look at that. But they said in the end you have to judge it on its own basis, its own grounds. What the judge did, abuse of discretion.
But what are we judging it for? Right? Before you were looking for substantial and compelling reasons. It's fair to say that we don't need that anymore, right?
Right.
Are we just looking for an abuse of discretion?
Right, but the abuse of discretion is also part of the proportionality, proportional to the offense and the offender, and it's got to make some sense. Again, it's a case determination, but you've got to take a look at the guidelines, which I don't believe this judge did. The Court of Appeals certainly didn't.
Okay, so we might agree on what the law is, just how it was applied in this case is what you want us to look at, what this judge did for an abuse of discretion under Smith.
Well, I think in this case, for sure, but also we're asking that the court, I guess, like I said before, reaffirm again that all these principles are to be observed and respected, that this court has gone through over and over again what the sentencing guidelines mean. I mean, when you talk about disparity in sentencing, which our legislature, that's why they created the guidelines in the old days of Milborn. And in this case, that wasn't respected at all. This woman, a cold-blooded murderer, and I'm not making light, any murder is horrible, but should it be up to the, I just don't get it. Should it be up to the judge?
Cannot a second-degree murder be a cold-blooded murder?
I don't know what cold-blooded means because we're attorneys. We go by the law and the elements, and here they acquitted her of first-degree murder. So cold-blooded murders.
That kind of flows nicely into the use of acquitted facts in the sentencing. The Watts case seems pretty clear to suggest there's no constitutional violation. Would you agree with that, the federal court Watts case?
No, I believe that some of the cases coming down, I don't have it in front of me, but with one case we cited from the Supreme Court when they stated that when somebody is acquitted, you go back to ground zero, pretrial conduct. And we're asking, and Amicus will speak more to that, that to the extent that Ewing says that this court reverse Ewing, that acquitted conduct should not be considered. We're not the federal guidelines. It's a whole different game. And we could see what it worked here, you know.
I know there are cases from New Hampshire and North Carolina that found procedural due process violations. Do you know whether those were based on federal constitution or those states' constitutions? I haven't had a chance to look at those.
No,
cases.
I don't, Your Honor.
Okay.
Counsel. I'm running up against my 10 minutes. I have no idea how to.
Counsel.
You have a couple minutes and just.
You let me know.
Can I ask you, please, what you think about this statement that was articulated by the U.S. Supreme Court in the Watts decision? They said sentencing enhancements do not punish a defendant for crimes of which he was not convicted, but rather increase his sentence because of the manner in which he committed the crime of conviction. Is there anything wrong with that statement?
Not as a bare statement. But again, we asked the courts, you know, to overrule Ewing, and in my case, specifically in my case, I think the court abused its discretion for the reasons stated in the Court of Appeals. Any way you look at the matter, just to say cold-blooded murder, and you know, Mr. Stack, the only problem he did was meeting you. And again, I'm not minimizing what happened here at all. But is it better that somebody stabbed some kid coming out of school that doesn't even know him? I mean, these people were in a pretty volatile relationship. He snorted, I think, 4 Vicodins that day and was drinking at 8 in the morning, and they had a lot of conflict. So
am I understanding you correctly that you're not arguing that the trial court considered inappropriate factors or took into account things that it shouldn't have been taken into account, but that when it piled all those factors up in front of it and tried to assess them, it abused its discretion and the weight that it gave to those factors?
I believe so, Your Honor, and also because of OV6, the arguments that were, you know, incorporated in our brief and, of course, made by the Court of Appeals. I don't think the judge in a murder case, when they found it was not premeditated, that he had the right to do that. And I think some of the decisions, I don't have the sites right in front of me, but they talked about that the guidelines were constructed by the legislature, so a judge can't just use his personal whims or his philosophies. I mean, because sentencing disparity is a big thing. It's the same in Jackson as in some small town, and in the thumb, it doesn't matter. The law is the law.
Well, you can't have your cake and eat it too, of course. To the extent the guidelines have been diluted by Lockridge and Steenhouse, the idea of uniformity of criminal sentences is also going to be diluted. That objective is going to be diluted. Not necessarily denigrated entirely, but it's going to be diluted at least, is it not?
Well, that was my thought to some extent. Yeah, diluted, but not that much. And again, it depends on a case-by-case basis. But here, there's no evidence that the judge really looked at any depth of the guidelines whatsoever. It was an emotional decision. And hopefully we'll have a different judge if and when we go back, because he operated from emotion, and we want reasons to be made up now. He said everything he had to say. The jury heard all the evidence.
Would you like to, if you have 5 minutes, just about 5 minutes, would you like to turn the podium over to you?
Oh, sure, certainly. Thank you.
Thank you.
Good morning, Your Honors. Jacqueline McCann on behalf of CDAM. I would like to speak briefly to the continuing viability of Smith since it came up. Please recall that in Smith, this court found that there were substantial and compelling reasons to depart. So the only remaining question was how do we use the guidelines range then to measure proportionality? And so I think that portion of Smith, using the guidelines range as that anchor or barometer to determine whether the departure was proportionate is still viable, and we would ask the court to leave that in place. As to the acquitted conduct issue, Your Honors, I would like to give a little bit of context.
But can I ask you a question, please?
Sure.
In assessing the reasonableness of a sentence under the current structure of the law, assessing a departure, do we look just at the incremental part of the sentence that constitutes the departure from the now advisory guidelines, or do we look to the totality of the sentence itself? In other words, do we look from 0 to 12 years, or do we look to the departure above the 8 to 10 year guideline range? What is it we're assessing?
Well, in Lockridge and in Steenhouse, this court maintained that the guidelines are still an important consideration. And so I think in order to give that substance in the context of an upward departure or an above guideline sentence, whatever we're calling it now, is you do still have to look at it in the context of the original range. So you're not just taking a look at it without that. So it is not the only factor, but an important factor.
But we're comparing the range to the ultimate sentence.
I believe that's still viable under Smith and under Lockridge and Steenhouse, Your Honor.
But it's a more flexible judgment. It's a more flexible consideration.
No longer requires substantial and compelling reasons. So yes, in that sense, it's more flexible.
Is it more flexible not just because the standard is different, but also because the guideline range carries with it less weight than it did previously?
Less weight than before, but still has the force of law. It's still different than this court's judicial guidelines from '88, or at least we hope the court still considers them to have more force than the '88 judicial guidelines, as they are still law, where how to thread the needle is admittedly difficult. And tomorrow I know the court will talk about the other end of this in Ames, and trying to fit it all together is admittedly difficult.
So that's the desire, but is there any authority? What supports the notion that once they become advisory, they're not the same as the judicial guidelines, which were themselves advisory?
I think in Lockridge and in Steenhouse, this court still recognized they have the force of law. But one thing I'd ask the court to please keep in mind, I know you chose the Booker remedy, but as you admitted or acknowledged in those opinions, it's not constitutionally required for the upward departures for the top end of the range. So every step this court takes to to weaken that top end as a step it doesn't have to take under the Constitution. And when you're the violation you're trying to remedy was the defendant's Sixth Amendment right to jury trial, it seems very Orwellian that the way to remedy that is to make it weaker and weaker and weaker. So we would ask the court.
That was the point of the dissents.
Sorry?
I think that was the point of the dissents in Lockridge and Steenhouse.
True, but this court has the authority to shape the Booker remedy any way it wishes, because it is not federally mandated remedy for the violation, as this court stated in Lockridge, and I think stated again in Steenhouse. So if the court is facing a decision as to whether to give greater protection than perhaps Booker does, that is within this court's authority. And the context I'd like the court to take into account that, maybe the reason that Mr. Skrotenboer hasn't seen this as a problem over the years is because the guidelines did require a substantial and compelling reason to depart, so there was that protection. But it is quite common in trials, especially in murder trials, where the defense doesn't necessarily have a I didn't do it defense, and the whole trial is about whether this was first-degree murder or second-degree murder. I'm filing an application in such a case today. That was the entire trial, and the defense won the trial. The jury found the defendant guilty of second degree rather than first degree. But the defense lost the sentencing because the judge believed that the act was premeditated and punished the defendant accordingly, and that shouldn't happen.
Thank you, counsel. Case will be submitted.